Hello, this is Simon Jackson from learnloads.com. In the UK Constitution Part 1, this is Part 2, I looked at where the UK Constitution comes from. In other words, the sources of the Constitution. At the end of Part 1, I mentioned three principles which, at least in theory, underlie the Constitution. These are the separation of powers, the rule of law, and the supremacy of Parliament. So in this second video, I'm going to say a little bit more about these three ideas. If you haven't watched Part 1, you might want to have a look at it by following the link here. You can easily find your way back to Part 2 by following the link at the end of Part 1, or just look at the Learn Loads channel playlist for law. So, let's get started. Separation of powers. Clearly, the state has got tremendous powers over people. For example, only the state can tax you or lock you up in prison. Those people within the state carrying out these powers can be divided into three categories. These are, firstly, the executive, the government, those involved in the administration of government, such as civil servants and the police. The legislature, group 2, category 2, the group which creates laws. In Britain, of course, this is Parliament. And the third category, the judiciary. In other words, judges who resolve legal dispute and enforce laws. Now, Montesquieu, a French 18th century philosopher, argued that legislative, executive and judicial powers should be exercised by different groups of people. This idea is known as the principle of the separation of powers. And the idea is to avoid the concentration of power into the hands of a single person or group. In simple terms, the other groups should act as checks and balances and discourage one part of the state from becoming dominant over the other parts, and perhaps more to the point, dominant over ordinary citizens. Keeping the power separate helps to stop any one of those three powers from, to use an old-fashioned English term, becoming too big for their boots. In a constitution with a clear separation of powers, the executive, legislature and judiciary are less able to oppress people through excessive power then. So in Britain, for example, government ministers only have such powers as are defined by Parliament. The courts can be asked by anyone to prevent government from acting outside of its legal powers. And we talked a little bit about this in Part 1, this idea of judicial review. Every year, thousands of applications for judicial review are made by ordinary people to the courts against government departments. These applications may be in relation to grave matters of life or death, or quite simple everyday concerns. In many one-party states, by contrast, the executive often dominates or even bullies the judiciary and or the legislature. So if we look at Myanmar, for example, repressive military rulers controlled not only the government but also the courts in the recent past in Myanmar, what was then Burma. They also ignored a landslide victory for the main opposition party in 1990 parliamentary elections. Principle 2, the rule of law. What do we mean by the rule of law? A second indicator of a stable, democratic, political and legal system is the presence of the rule of law. And then there's three strands to this. Firstly, nobody should be punished by the state unless they've broken law. The same laws should apply to officials of the state as to ordinary people. And finally, the interpretation of established laws defining the rights of the individual is made by an independent judiciary rather than the executive. So, the rule of law does not mean that whatever is ordered by a ruler able to dominate the people of a country in some way, whatever they say, that has to be followed. That's the rule of law. And that doesn't mean that. A dictator can impose laws on people through force of arms or by other means. What we really mean by the rule of law is that settled and agreed laws apply to everyone in all situations, and that no one group, either within or from outside of the state, is above the law. In stable democracies like the UK, it's tempting to take the rule of law for granted and assume that the state always follows the rule of law. Well, however, even in the UK, the rule of law has sometimes been ignored. In Northern Ireland, between 1971 and 1975, which was a period of intense terrorist activity in Northern Ireland, hundreds of suspected terrorists were held in custody for lengthy periods without being charged with a criminal offence. This was seen as a breach of the rule of law by some critics. So people were being punished by the state without it being proven in the courts that they had acted illegally, that they had in some way broken the law. Third principle is the supremacy of Parliament. Supremacy of Parliament is sometimes called parliamentary sovereignty, and what it means is that Parliament is the highest source of English law. There's several implications to this idea of the supremacy of Parliament. Firstly, although the courts can and do make law, they're obliged first and foremost to apply the laws that Parliament makes, those acts of Parliament. However well established judge-made law or common law may be, if Parliament passes an act that changes the common law, judges are obliged to apply that act when they're deciding cases, whether or not they prefer older common law rules. A second implication of parliamentary supremacy is the idea that Parliament sometimes gives other people, such as government ministers or local authorities, the right to create binding laws. These laws are known as delegated legislation. That idea of delegated legislation does not affect parliamentary supremacy when you think about it, because any legal entitlement to make delegated legislation can be altered or taken away by Parliament. Third point to say about parliamentary supremacy is that, in theory at least, Parliament is free to create bad laws. So an act of Parliament requiring grandmothers to be hung, drawn and quartered for purchasing custard cream biscuits would have to be enforced by the courts and the police. Parliament is not bound to create laws that comply with any particular notion of right or wrong. Many other countries do require parliaments to comply with fundamental principles of human rights set out in a separate document, a Bill of Rights. The USA, for example, has a Bill of Rights that enables a court in the US to strike down laws as unconstitutional. Now, in Britain, despite the Human Rights Act 1998, without going into that, this is not the case. Fourth thing to say about parliamentary supremacy is Parliament cannot bind itself. It's part of the Constitution that any act passed can be later repealed, either by the same Parliament or by any subsequent Parliament. So, there you are. A brief guide to three important principles in constitutional law: the separation of powers, the rule of law, and parliamentary supremacy. Hope this helps. Thanks very much for listening. If you want to see lots of other videos about the law, please have a look at the Learn Loads YouTube channel and follow this link to our website for more help and more free resources. Thanks a lot. Bye.